Okay, let's get started. My name is Alex McGarris, a partner in Venable's New York office and part of our advertising and marketing law group. Thank you again for joining today's webinar, and apologies that we are beginning just a few minutes late. We will be talking about legal considerations when managing and protecting your brand online, and specifically the rules of the road with respect to soliciting and managing customer reviews online. Of course, every brand is hyper conscious about its reputation and how it's being depicted online, but also increasingly focused on harnessing the power of customer feedback and product reviews to promote and stand apart from its competitors. Accordingly, we've seen the regulators, and in particular, the Federal Trade Commission, pay close attention to the various ways brands are managing this process. And we'll talk about the regulations that govern this, but also how the FTC has used its enforcement authority to regulate companies and how they use customer reviews. Just a bit of housekeeping. This presentation is available for CLE credit. I will announce the code that you'll need to use to get credit in the middle of the presentation. And so here's kind of what we're going to cover in this webinar. I invite you to submit questions using the Q&A feature, and I will do my very best to get to them at the end of the presentation. In the event that I have already planned to cover the topic, it's best to do it at the end. If for some reason I can't get to them because of timing constraints, I will reach out to you, the questioner, by email, and happy to converse that way. So today we will cover 3 areas with respect to soliciting and using customer reviews in advertising. First, we'll talk about when reviews are considered to be paid endorsements, and then the requirements that flow from that. Second, what happens when a customer review includes a claim about the product or service your brand offers, and the customer is discussing what's required of the company. And then finally, it's not just the actual kind of text of the review that you need to worry about and disclosing whether or not there's a material connection. You also need to be cognizant of how the reviews are formatted, displayed, and aggregated and presented for potential UDAP concerns. And when I say UDAP, I mean unfair, deceptive advertising practices. And so we'll discuss what companies have been doing and things that have gotten them into trouble with the Federal Trade Commission, specifically in that area. So first topic, reviews are endorsements by your customers. The FTC has published, I think in the 70s, a set of guides concerning the use of endorsements and testimonials in advertising. They've been updated over the years to reflect new media, from moving from television to social media and online platforms. These are published in the Code of Federal Regulations, so it's a formal process that is undertaken to update the rule. It is a very useful set of guidelines, and anyone that is advertising using either paid spokespeople, experts featured in advertisements, or relying on customer feedback in advertising absolutely needs to be familiar with these guides. An endorsement is any advertising message that third-party consumers are likely to believe reflects the opinion of the endorser and not the advertiser. This even includes tagging a brand on a social media post. You don't need to use words to convey a positive message, but images and actions and clicks like liking a product is considered to be conveying a positive message. So, for example, a television commercial where there are two actors kind of discussing a brand of soda, that's not an endorsement, right? It's obvious that the message in that ad is an advertising message by the soda company. Contrast that to, for example, maybe a famous athlete that appears on a daytime talk show and he discusses the benefits of a certain brand's fitness product. The reasonable viewer of that program will likely believe that this athlete is expressing his own opinion and not the opinion of the fitness company. And so that would be considered an endorsement. These guides are interpretations of the FTC Section 5 authority, which prohibits UDAPs in advertising. It expresses the Commission's views about what is in conformity with Section 5 when dealing with endorsements. They don't have the force of law, but the FTC has made it very, very clear that advertising practices that are inconsistent with these guides may result in corrective action or an enforcement order by the FTC. And so, while these guidelines again do not have the force of law, they very much represent the Commission's current thinking about advertising and endorsements. To keep up with changing technology and applications of this technology to promote endorsements, FTC has also published an FAQ on its website that is updated much more frequently than the guides themselves. And so I will be referring to them throughout this presentation. They're actually pretty user-friendly and contemplate via an FAQ format a lot of different scenarios that endorsers and influencers and brands confront when navigating this area of advertising law. So the guides do apply to customer reviews, and so the various rules that are embedded apply to online reviews. And so here are some of the kind of the basics of what the FTC guides on endorsements require. So first, just basic truth in advertising principles. Endorsements must reflect the honest opinions of the endorser and have to be from a bona fide user of the product. So paying for likes from bots that are not real users of your product would be considered to be on UDAP and violative of the FTC Act. Second, and related, the endorsement itself cannot contain false or misleading information. It's as if the brand, by relying on or incorporating the review in its advertising, is making the statement itself. And so everything in the endorsement or review has to be accurate. And third, the advertised portion of the endorsement must reflect the spirit of the complete endorsement. So in other words, if a customer leaves a long post and has mixed reviews about a product or service, if you are going to be modifying the review in any way or taking an excerpt of it, you have to be mindful of whether or not it undermines the entire spirit of the ad. You can't cherry pick pieces of the review if that's going to be, the omission is kind of deceptive about that customer's real experience or opinion. This next principle we will discuss at some length towards the end of the presentation. Reviews cannot be used to make claims that you, the advertiser, cannot make yourself. And so basic concept in advertising law is that you cannot make a claim about your product unless at the time it's made you have sufficient backup or substantiation to support that claim. And so similarly, reviews can't make unsubstantiated claims. Endorsements conveying results of a customer must be typical for a customer of your product or service. We'll also discuss what that means. If the endorser is an expert, comes across as an expert, saying it as an expert, I am endorsing, or and as an expert, find that this product works, etc. That expert's qualifications must kind of relate to the specific product that he or she is endorsing. So if you have a medical doctor saying that they are reviewing something that's, for a dentist, that's not going to be properly qualified to express that opinion. And then finally, and here's what we're going to talk about in this first section, material connections that might affect the credibility of the review must be disclosed. So for example, if there's any connection between the reviewer and the advertiser that a third-party customer reading that review would not expect, that connection should be disclosed. That means, at least as the FTC has interpreted it, that the default rule should be disclosure. And we'll talk about when it's required and how to properly make the disclosure if you are incorporating customer reviews in your advertising. So the first type of material connection that oftentimes leads to these issues relates to people who work for the brand. Obviously, getting a high volume of positive reviews these days is critical to getting ranked on third-party review sites or third-party commerce sites such as Amazon. I mean, that literally determines if your product will be seen at all by someone browsing on that marketplace. And other examples of why it's important include, where sites like TripAdvisor and similar review sites allow users to filter based on that rating given by other customers. And so having many and having good reviews is critical to even have your product show up in these results. And so this causes a huge incentive and demand on brands to get and generate reviews. It's really hard to get a customer to go out of her way to submit a positive review. Not so hard to get for a customer to make a negative review or file a complaint, but to file positive feedback is a little bit more difficult. And smaller brands and smaller companies especially really need that in order to generate some buzz. And so to address this conundrum, brands have created or hired agencies to create, various campaigns to help them increase their online customer reviews. And so, for example, asking friends and family or employees to submit customer reviews either on your site directly or on third-party sites is something that companies do all the time. However, posing as a kind of independent, unbiased customer is considered deceptive. I think it's pretty common sense that someone reading that review would not know that the person writing it is an employee or an owner or the parent of the owner of the company, unless that's prominently disclosed in the review. There's no other way for the customer to know about that relationship. And so disclosure in that situation is absolutely required. FTC has and continues to find situations where companies are not just permitting employees to submit reviews, but encouraging them. In October of 2019, so about a year and a half ago, the FTC entered into a settlement with a cosmetics brand, well-known and featured in Sephora's stores and on Sephora's online marketplace. And after the FTC conducted its investigation, it discovered emails where the managers and owner of the cosmetics brand were telling employees that they have to submit fake customer reviews and instructing them how to avoid detection by Sephora.com's website parameters that try to identify fake reviews. So of course, the company ultimately settled with the FTC. They're prohibited from engaging in this type of conduct going forward. And although the settlement did not require the company to make a payment either to the government or to customers in the form of refunds, one of the commissioners, Commissioner Chopra, wrote a dissenting opinion on why he thought that the settlement was too weak, given the conduct, given the emails that were unearthed, and he strongly expressed the desire that the FTC demand restitution or some form of disgorgement of profits going forward in these types of cases. And part of his dissent describes that these types of practices distort the marketplace because customers are unable to, when sifting through these reviews, tell the difference between a bona fide customer review or an employee posing as a customer. Fast forward to March of 2020, another settlement was entered into with a wellness company. Amongst the allegations there was that the company published reviews, purporting to be from users of these health products, but in fact they were employees of the company. There was a monetary penalty, but as noted on the slide in front of you, there were other allegations in play here that made the conduct more egregious. The second type of, and so just to recap, disclosure is required if an employee or other person that has a special relationship with the brand is submitting a review, either genuinely or not genuinely posing as a customer. The second type of relationship that gives rise to the need for disclosure in customer reviews is where the brand compensates the customer somehow to submit a review. The types of programs out there who we've all seen as consumers and have reviewed as marketing professionals, range from free products, discounts if you submit a review, entering a customer into a sweepstakes if he or she submits a review, and even making a charitable donation each time someone submits a customer review. These are all forms of compensation or incentivization that, according to the FTC, is material, is something that would impact a viewer in giving weight, assigning weight to the review, and something that needs to be therefore disclosed. And so no matter how small the incentive is, the FTC has even said if it's a $1 off coupon to encourage someone to submit a customer review, that requires disclosure. And so if you, as the advertiser, are including reviews that were incentivized by you or an agency you hired in your advertising, you are responsible for ensuring there is sufficient disclosure of that incentive. To be clear, if you're simply encouraging your customers to post reviews about their experience, and there's no reason for those customers to expect compensation or any other benefit before giving that feedback, there's no reason to disclose anything. But if there's any reason for these customers to believe they'll be receiving some sort of benefit in exchange for a review, regardless of whether or not it needs to be positive. Even if you permit them to say anything about their experience, that needs to be disclosed. And the FTC guides, but also the FAQs that I was referring to earlier, include pages and pages of hypotheticals where different scenarios are posed, and the FTC describes kind of why disclosure is required. I don't think there's any examples where the FTC concludes disclosure is not really required. And so even if it seems absurd to have to disclose that customers were offered a coupon for a future purchase, that is the FTC's position as of today. So how do you disclose these connections? It's very similar to influencer posts and how those material connections need to be disclosed on social media. The FTC's FAQs include a lot of hypotheticals on how to disclose. They start with saying that there is no magic language, but they also provide some meat as to what's not sufficient, and that's what we'll go through today. That said, it's very fact specific, deciding or determining what is a sufficient disclosure. One really does need to take into account everything that's going on in the ad on the web page. So the format of the ad, the platform that it's being posted on, size and color of font, and all of that, what else appears in and around that review, all of that impacts how the disclosure needs to be made in order for it to be clear and conspicuous. But here are some kind of guideposts that the FTC has published, and that I think provide some pretty good, maybe not satisfactory, but good insights as to what they're looking for. So first, the disclosure needs to be specific about the nature of the relationship. And so if the reviewer is posting and he's an employee, even though, and he received the product for free, just saying that he received the product for free is not going to be sufficient. He'll also need to disclose that he's an employee of the company and brand that the product is from. Ideally, the disclosure would appear with each review, but a general disclosure that everything on the web page, that all the reviews, for example, appearing on the web page were incentivized by XYZ. That probably could work. Again, that very fact specific about how that disclosure appears, but that's probably an option. For looking at the next bullet, for multimedia content like a YouTube video, the FTC has stated very specifically that the disclosure needs to be in the video itself, verbal, and not just submitted with the written description that's uploaded with the video. For Instagram posts, the disclosure needs to appear above the fold, meaning on the lines that are visible without clicking to see the rest of the text. FTC has even gone so far as saying how Snapchat and Instagram story reviews should be disclosed. They advise superimposing the disclosure over the image. Since the beginning of kind of the influencer movement, the FTC has endorsed hashtag ad or hashtag sponsored as a sufficient disclosure. Obviously, that's very easy for Twitter, given the limitations there. So that's still okay. One thing that the FTC has come back to clarify is that hashtag ambassador is not sufficient, but it would be okay if it's hashtag the brand and then underscore ambassador. And so, and then finally, just simply having the reviewer or influencer say thank you. So, thank you is not going to be sufficient. It would really need to be more specific and saying, thank you for the free trip or for the free video game, etc. So that's how to disclose to the extent you are using these reviews in your advertising. But what are a brand's responsibilities if customers are posting reviews without sufficient disclosures or with other issues on third-party review sites? The FTC has updated its FAQs to address this. Again, as the FTC has specifically said that advertisers need to have policies and procedures in place to monitor members of their network. So if they are incentivizing customers or influencers to submit reviews, and there's an exchange of compensation, that the brand has to kind of train or at least explain to these customers what their obligations are, and to monitor the third-party sites for their compliance. This is very difficult. It's kind of a new area because what really can you do if you find non-compliant posts or reviews? Like, I know the FTC would say that you shouldn't continue to offer these discounts or free products to people that are not complying. I think also the FTC would take a reasonable stance with respect to one-off issues with customers who are not influencers that are part of a network that are kind of on a recurring basis receiving incentives to promote the brand. But that said, that that is something that companies that are using pretty elaborate campaigns to generate reviews need to be aware of and need to think about in terms of including in their compliance program. Just a couple of recent enforcement actions with respect to disclosure of compensation for reviews. There were a spate of them several years ago, especially in the video gaming world. But more recently, we've seen a settlement with a company that sells supplements. In addition to having health claims that were not substantiated, the company was incentivizing or giving free product or lifetime memberships to customers to submit reviews, and that was not disclosed. The final order required the company to disclose all material connections. Then in March of 2020, another settlement with a skincare and tea product company where the brand was using celebrities such as Cardi B to promote the products, and there were no disclosures there. And the FTC took the position that even though Cardi B is famous, it's not obvious that when she's talking about tea or skincare that she's not expressing her own unbiased opinion, and therefore the disclosure is still required. Moving on to the second kind of area on customer reviews and things to be aware of is reviews that contain claims. Just basic advertising law 101, you cannot use or not make claims in your advertising that are not sufficiently substantiated. And the scope of this webinar doesn't include what that means. We can spend a whole day on what is sufficient substantiation for a given claim or a given product, but the point is that advertisers cannot say through a product review what they can't say directly themselves. And so here up on the slide is an excerpt from the FAQs published by the FTC, where it discusses kind of what's required there. And one of the examples that's given is where a blogger is commissioned by an advertiser to review a new wellness product. And even though the advertiser on all of its advertising doesn't say anything about the lotion's ability to cure anything, if the reviewer that is receiving free product to review, if the reviewer says something like the lotion can cure eczema, the advertiser cannot include that blog or excerpt of the blog in its advertising. It would be subject to liability there, but also for those of you that are listening that are influencers or bloggers yourselves, the blogger is liable for false and misleading advertising. One of the more vexing aspects of the guides relates to customers who have had exceptional versus typical experiences with the products and services that they are reviewing. The FTC takes the position that an advertisement that's containing a review or endorsement relating the experience of one of its, exceptional customers, that review will likely to be interpreted as representing something that's typical of all customers, what all customers can expect to achieve if he or she is bought or using the product. And so if the advertiser does not have substantiation that the specific endorser's experience is representative of general population of customers, then the ad either can't be made, can't include it in your ad, or you have to disclose what a typical customer should expect. And so that's really difficult for a lot of brands to comply with because they may not know or track what a typical customer can expect or achieve in terms of results. And so obviously, customers that are submitting reviews either voluntarily or as a result of some sort of incentive are typically those that had really good experience. And so deciding whether or not that customer's experience is exceptional as opposed to exceptional as opposed to just really good is a really hard line to find. And I think it's become really difficult to provide that disclosure of what is generally achieved or expected by consumers of a product. I think folks, first thing they want to do is just include a disclosure that says, these results are not typical. And that was something that was certainly done years ago. The FTC then commissioned some studies and tests to see what those types of disclosures do to a customer's takeaway. So for example, they tested a clear and prominently disclosed results are not typical disclosure. And according to the study, that the disclosure was not adequate. It did not reduce a customer's takeaway that what the endorser was saying is generally representative of all customers. And so the FTC has strongly suggested that such a disclosure, results are not typical, is not sufficient. It said that we cannot rule out the possibility that a strong disclaimer would work. They, based on their testing and studies, have concluded that it's really hard to change the takeaway from that type of endorsement. And so be really careful when you're dealing with a product or service that has kind of concrete results. If your reviewers are touting them, you need to make sure that what they're saying and their experience is generally representative of all purchasers. And so with that, we will move into the final area, and that relates to managing negative reviews. So far, we've been talking about, how to harness positive reviews to promote your brand and some of the legal pitfalls that those efforts present. But what about the negative stuff out there? The internet is full of all kinds of statements and commentary. It's very easy now for customers or competitors posing as customers to just say all kinds of things about a company or a brand and the products and services. Certainly our internet trolls out there, and my clients on a daily basis ask me what they can do to help manage their online reputation, clean up what's unfair or distorted out there, and short of sending a cease and desist for someone posting something defamatory, inaccurate, or infringing on your IP. what really can you do to protect your brand? And the purpose of this presentation is to identify the legal risks of various efforts. One thing I want to start with is, what's the law? We talked a little bit about UDAPs, unfair, deceptive advertising practices. The concept of unfair and deceptive advertising being illegal is from Section 5 of the FTC Act. It's been around for a very, very long time, although constantly being reinterpreted by the FTC in courts. But more specifically, Congress passed in 2016 a statute called the Consumer Review Fairness Act, giving the FTC and state AGs enforcement authority and ability to get penalties. The purpose of this statute is to protect consumers' ability to share their honest feedback and to promote transparency and free speech. The Congress was responding to what they were seeing was an increase where the FTC and other consumer protection watchdogs were seeing proliferation of contracts or terms and conditions in consumer transactions where the brand made consumers essentially agree to not say anything negative online about the brand. And so the statute was passed to combat that. It makes it illegal to have gag provisions in your form contracts with consumers. And it requires the company to, or prohibits the company from prohibiting disparagement online. Most interesting, though, is what's not covered by the CRFA. And so reviews that customers post that disclose confidential or private information about the brand or about other people, those can be, those are enforceable to seek that they get taken down. Reviews that are libelous, harassing, obscene, vulgar, or inappropriate, which is not defined in the statute, those two can be, companies can try to get those removed or pursue a customer for making a post that includes that type of content. Reviews that are unrelated to a product or service, and reviews that are clearly false or misleading. Before I forget, the CLE code is Protection 2021. Again, the CLE code is Protection 2021. And so the CRFA is, very specifically applies to provisions in a consumer-facing contract that prohibit consumers from, except in the scenarios we just saw, that prohibits consumers from posting, negative feedback or reviews about a company's products or services. But what are other, there are other tools that brands use to, manage negative customer reviews? And increasingly, I'm asked, what are our obligations when we solicit reviews and post them on our website? And what are our rights if we see inappropriate, inflammatory, false content in a review? And so I just want to go over in our last few minutes together some cases that are more focused on the manipulation or management, moderation of negative reviews that companies have tried to do in order to present what they would say is a more accurate picture of their brand, but the FTC would say is suppressing or stifling kind of customer feedback and an accurate picture of what customers are saying about your brand. Last May, a year ago, the FTC entered into a settlement with lendedu.com, and there the company was kind of ranking companies in a certain financial services space based on, according to the website, objective, unbiased information about these third-party companies' products. But in fact, companies kind of could pay to play. They were able to get ranked higher on this website if they paid the company hosting and operating the website. And so that was not clearly disclosed to customers. They thought the ranking was based on objective criteria, the merits of the product and services, but really one can, manipulate their standing in the ranks of the website by paying. And so the operator of the website was investigated and ultimately settled with the FTC. In another case brought in January of 2020, the FTC alleged that this company was, in response to negative reviews by customers on Yelp, was disclosing personal information about those customers as sort of an attempt to deter others from doing so. So kind of penalizing customers for submitting negative reviews. The FTC found that that practice was deceptive and unfair, and so there was a settlement there with a fine paid. And then finally, and this one I find to be the most kind of informative for companies out there trying to understand, especially if they are posting reviews on their own website, what the FTC is thinking. So in November of 2020, the FTC published what's referred to as a closing letter on its website, announcing that it had conducted an investigation of a company called Yotbo, but decided not to bring an enforcement action. It's a very short letter, a page and a half, I think, and provides some nuggets as to why the FTC is decided not to bring a case and what it expects. Yotbo provides a service to e-commerce companies that allows them to collect customer reviews. So think about, when you buy something online, oftentimes you'll get an email within a certain number of days of the purchase asking you to review the product. And that automatically gets sent to you by email. And that information is then uploaded somewhere, right? So Yotbo provided that type of service that sent these types of solicitations, collected the reviews, and then allowed the reviews to be posted on the website. But also, it's an application that allows the brand, the e-commerce company, to manage the inbound reviews, to look at them based on different filters, to respond to the customer, to basically deal with any customer service issues. So it's a tool that allows you to manage the reviews. And the FTC, was looking to see if the company was providing the means and instrumentalities to help other companies deceptively suppress negative product reviews on their websites. And so in other words, the FTC was saying that the tool in allowing a brand to suppress, for example, certain reviews or all reviews with a low rating or whatever the different filters allow you to do, that would be deceptive to other customers visiting the website because it didn't accurately display or reflect the views of all purchasers who submitted reviews. In deciding to close the investigation against the technology company, FTC looked at a number of factors, which I think are insightful. First, Yotpo's commitment to implement measures to protect against the misuse of its review management services to suppress or delay the posting of negative reviews. The FTC went on to say that Yotpo is implementing clear and prominent guidance to its clients on the need to promptly post reviews, including negative reviews. And Yotpo also committed to automatically post negative reviews that have not been promptly reviewed and acted upon by its clients. And so here's a closest thing I've seen to an FTC statement that negative reviews need to be posted if you're collecting reviews, which is, the slippery slope there is extraordinary. The FTC in a footnote went on to say that sellers are not required to display reviews that contain unlawful, harassing, abusive, obscene, or vulgar content. So similar to what we saw in the exceptions under the CRFA. So at least there's some common sense there that, a brand should not have to post reviews that contain that type of content. But still, it is quite extraordinary to say that on your own website, where you're soliciting customer feedback, that you have to post negative feedback without more information about, potential exceptions. If, for example, the customer service issue prompting the review gets resolved, does the company still need to post that review? Can the company ask the customer to post a new review, or is that also deceptive? And so the FTC very clearly says in this footnote, sellers should not withhold reviews that relate to bad customer service. And so I think we will be seeing more from the FTC there. The FTC is considering updating the endorsement guides. As I mentioned, it has to go through a formal rulemaking to do so. February 2020, it began the process. It sought public comment as to whether to make changes. It's a wide review of the guides. Only a piece of it relates to customer reviews, but specifically it did seek comment on these three areas. First, whether incentives actually bias customer reviews. I think that's a really good question to ask as a starting point, because that's assumed in the requirement to disclose. Second, whether composite ratings that include reviews based on incentives are misleading. This is really interesting when you think about it. So let's say you do incentivize customers through a discount or something to post reviews, and the disclosure is made. And part of that review, customers also get to choose a rating, 5 stars, 4 stars, whatever. If you then calculate an aggregate rating for that product, looking at all the reviews and say it's 4.5 stars, this average is 4.5 stars, is that deceptive because it's not redisclosing that the underlying review was incentivized? And then finally, what, if any, disclosures advertisers or operators of review sites need to make about the collection and publication of reviews to prevent them from being deceptive or unfair? And this dovetails to what we just discussed with respect to the Yotpo closing letter, where the FTC is strongly suggesting that negative reviews that are collected need to be posted, and any type of filtering that's done before, where some reviews are not posted, needs to be disclosed. With respect to the status of this, comment period closed last summer. FTC received 118 comments. It's pretty small for rulemaking, so it shouldn't take so long to go through. But the FTC is in a weird place right now. It's down a commissioner, and the fourth commissioner is slated to potentially take over as the director of the CFPB, which would open another seat. So we haven't seen any updates from the commission as to what's happening with this update to the guides, but hopefully in 2021, we will get a better picture of where that's going. I think an update might make sense. And then finally, just some best practices to ensure you're complying with the Consumer Review Fairness Act. Review your form contracts, including the website terms and conditions, to make sure there's no gag provisions in there. If you have customer transactions where that type of language was included, you should reach out to your customers saying that it's not valid anymore. Don't cherry pick reviews unless it's very obvious that you're cherry picking, one or two reviews because they're, positive. But otherwise, be really careful when applying filters on your own website. Remember, the FTC Act applies, and so any questionable conduct can be reviewed and challenged by the FTC under Section 5. And unfortunately, we're in a situation where, it's really hard to predict where the FTC is going next with respect to what it considers to be deception with respect to native advertising, or in this case, endorsements and testimonials. And so a conservative approach is certainly advisable. With that, that's the end of my presentation. I don't think we have any questions, but given we started 4 minutes late, happy to stay on for a couple more minutes. If you have any questions, just submit them in the chat box. And if not, thank you for your time today. Hope it was informative and worth your hour. I appreciate it. We have a question. What if a reviewer / customer decides to post a review and it's for off-label use, but there's no material connection at all? Well, so if there's no connection, there's nothing that either the reviewer or the brand needs to do with respect to disclosure. Obviously, if you intend to incorporate it into any type of advertising, you'll just want to make sure that there's nothing in it that's either false or unsubstantiated in terms of claims about your product's efficacy or results one can achieve. Second question, what if someone repudiates my product? What if it is a competitor? So if it's if you suspect that the review is being made not by a bona fide customer but by a competitor, then obviously it's not a real review, you can certainly try to enforce your rights if you can figure out who that person is. I have clients with respect to reviews that they solicit themselves and post on their sites. They can check to see if it's a real customer. If they suspect that it's not, they won't post it. I think that's fine. But if you have no way to do that, then you probably need to assume that it's a bona fide customer. Another question is about affiliate marketing, which is a great one. I encourage you to look up these FAQs because there's actually a new section in them about affiliate networks. The FTC's guidance there is similar to what I was saying about a brand's responsibility for reviews that are made by customers without their encouragement on third-party sites that they don't control or operate. The FTC has said, if you are the network, you should at least advise the companies, the publishers, and affiliates in your network as to what their obligations are. But ultimately, the advertiser is responsible, as is the affiliate itself. I think networks, though, are smart to include, at least in its terms and conditions, maybe in other ways, some basic information, putting their affiliates on notice of their obligations and asking them to represent and warrant that they will comply. These non-disparagement or gag clauses are prohibited in consumer contracts, not B2B contracts. Obviously, some B2B contracts really are B2C, so I'm not going to advise there, but it's for consumer transactions. Final question I'll take is, when posting reviews on your website, can you clearly disclose something like, here's what some of our happy customers are saying about us? Disclose that we have cherry-picked which reviews we post. Without, seeing how that statement's made, what else is on the website, and all of these caveats that I have to make, I tend to think that that's fine if it's well disclosed. That said, if you have reviews on multiple web pages, then you would need to make sure that disclosure follows. And then also, if you have like tens of thousands of reviews, it's probably it's more likely that a customer reading them would assume that all are being posted. If you're cherry picking, 10 reviews, I think that's more obvious that they're cherry picked. But if you're posting tens of thousands and you're saying they're cherry picked, that may not jive. That said, you may do that type of volume, but I think that's one factor in assessing what a reasonable consumer's takeaway is with respect to which reviews are posted. So thank you again. I hope you have a wonderful Wednesday and a great Memorial Day weekend.